The U.S. Securities and Exchange Commission, SEC, made a surprise attack on the Ripple case by filing a letter of supplemental authority to strike Ripple's fair notice defense. Simultaneously, the token XRP is down to 33% in the last 24 hours to $0.7 following the market's downtrend. As the popular SEC versus Ripple case is expected to be resolved around April this year, the SEC has made a new move that left many wondering if previous expectations could change. The American regulator is using a winning move from another case to strike at Ripple's key arguments. The SEC had taken John M. Fife and 5 entities controlled by him to court in September 2020 for selling $21 billion of penny stocks and gaining a profit of $61 billion without registering as security dealers. Fife's defense adopted an argument similar to Ripple's, alleging the SEC hadn't given them a fair warning and the term dealer can be widely interpreted. Last month, the court denied this argument. Naturally, the regulator now aimed to use this denial to strike at Ripple's fair notice key defense. Similarly, Ripple's fair notice defense alleges the regulator failed to notify them about a possible violation of federal securities laws and claimed the term investment contract is being misused by the SEC, adding that the SEC's theory, that XRP is an investment contract, is wrong on the facts. In fact, just the opposite is true. The U.S. would be the unfortunate outlier. The SEC is using the Fife case latest outcome to insist that the term investment contract is bound by legal parameters since 1946. In Ripple's case, binding authority construing the term investment contract has existed since 1946. W.J. Howie Company, 328 U.S. at 298-99. Thus, Fife provides additional authority for striking Ripple's fourth affirmative defense. However, the cases have distinct terms. The attorney Jeremy Hogan explained via Twitter that the Fife case outcome marginally helps the SEC's position in its motion to strike Ripple's fair notice defense, so the SEC filed it with the court. Although the SEC is trying to make a move out of the similarities from both cases, Hogan claims Th. In the Fife case, the defendant tried to argue fair notice in order to dismiss the lawsuit entirely, and failed, because the burden is very high on a party moving to strike a pleading. In the Ripple case, it's the SEC that is trying to strike the affirmative defense of fair notice and it has the high burden to meet. Ripple CEO Brad Garlinghouse had remained hopeful at the end of 2021 as he expressed to CNBC, "Clearly we're seeing good questions asked by the judge. And I think the judge realizes this is not just about Ripple, this will have broader implications." Related reading: XRP builds momentum with 7% increase as Ripple launches new ODL partnership. Related reading.